Welcome, everybody. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. Thanks for joining us. I'm your host, Todd Ryan. I have two co-hosts, David Michaels and Jeffrey Neuman. Jeff is in Prague today. I call it Prague, like The Hague, but he's in Prague today at ICANN 83. Sounds like a year I graduated from high school. Tried to get David up here on stage. Oh, there he is. That's my co-host, David Michaels. Hey, David, how are you?
I'm good. How you doing there in Los Angeles area?
Yeah, it's it's going good here. Well, of course, on the news, they try to make it. I say always try to make it look like, hey, there's a fire here, there's riots there. Los Angeles is pretty big, so in certain areas, I was curious. I know Fred at D3 has an office right downtown. I have some friends, attorneys that have offices right downtown, and I know Ishmaeli has an apartment downtown, but I'm not near there. I'm way up on the 101 just in Ventura County. So I'm, 50, I don't know, 50 miles from downtown, about 35, really 40. But LA's big, so you hear about this stuff, and it's a pretty massive place. So it's really in certain areas, but I haven't even looked at the news today. It looks like everything's all calm as silk. I don't know, calm as silk. I mean, smooth as silk. Um, Other than the president trying to cause fucking problems. I mean, we got it out here, okay? We can handle what's going on, what's happening out here. People are upset. Of course, everybody's nervous to death. I just got to say, it's like when I say about tailgaters. If you tailgate, you're a dick. Okay, that's all there is to it. If you're somebody who tailgates people, you're a dick. Um, and the same is if, I don't know if a lot of people are familiar with well, immigration, but there's a lot of folks who say 20 years ago somebody came here on a visa and their visa was good for 6 months. They overstayed, so they immediately became, as some people want to say, illegal. They're illegal people then. So people overstay their visas, and then I guess my point was that when someone has done this, say 20 years ago, and has been here the whole time working, and right, they overstayed their visas, so they are considered illegal, I guess, by some here. I consider it, they're undocumented. But the point is, a lot of these people who have been here for a long time, whether they've had families or jobs or whatever, when if you're somebody who thinks they should be, removed and not have some pathway here if they're a law-abiding citizen, other than that overstay, right, of that visa, then you're a dick. Okay, so that's just the facts of it. Because there's just so many people that are afraid here, from kids to uh, it's just terrible, the fear that's been put into millions of people, and for no reason. So anyway, that's my on that. Um, but we're taking care of it here in LA. We don't have a lot of news today. There's a few things I was going to talk about, but Jeff, he's over in Prague at ICANN 83. He's going to give us an update next week. We really look forward to that. He said he already texted me. He said a lot of stuff was going on. Talked about some conversations that he had. I thought were really interesting. One thing I want to mention to you that are here, early listeners. Thanks for joining us. So I am going to be at NamesCon in November, and I reached out to a guy some of you may know. His name's Robert Smigel. He does Triumph, the insult dog, right? The insult mutt. Anyway, been on Conan for years, but he's just funny. He was a writer for Saturday Night Live, and him and his producer Frank Smiley. So I reached out to them and said, "Hey, I'm going to be uh, speaking at NamesCon, and I'd like to roast a lot of people in the domain space. Of course, I can do it myself. I don't need any help, but these guys are experts at it. So I'm going to speak with them this week about here's a lot of the folks that are going to be showing up. Here's a little bit of their history." So yeah, this ought to be fun. I mean, if you're going, I don't know how much I'm going to tell the NamesCon people about my little act, but we'll see what happens. Hey, David, what do you think about that? Good idea?
Sure, definitely roast them.
Okay, but it'll all be in good fun. Hey, Today, did want to mention that before we got 5 cases we're really reviewing today. We're going to talk about. I didn't intend to overload us, David, with 5 cases, but you saw one was a sub case of another case, and then I couldn't help myself with the farewell.com case. So we actually have 5 cases we're going to talk about, and we're going to jump into it pretty quickly. Probably get through this thing early today. Everybody gets out of school early. But I did want to say there was a couple things. Oh, I did see there was a case that we're not going to cover, capitalbayfunding.com. I just was reading dnw.com. You know, Andrew Alleman has a great blog there. I think you all know this. But he mentioned a case that I wasn't aware of. Apparently, it was a complaint denied, capitalbayfunding.com, David, where this Capital Bay Funding, there was somebody on, basically fraudulently pretending that they're Capital Bay, this company, this, I don't know, sound like maybe an investment advisor. Who knows what they're doing? All I read was the headline, a little bit about it. But basically, this company was clearly doing something fraudulent and, targeting users that thought they were this other company. But because the Capital Bay Funding didn't, the complainant couldn't show that they had a trademark that didn't supply enough evidence showing their common law mark, that the complaint had to be denied, and or that's how the panelists ruled. But interesting because, like the panelists said in this Capital Bay Funding case, when we talk about it next week, if you can't come in here and show that you got a registered trademark, then you really need to provide a lot of evidence that you do business as that particular name that you're claiming, and show us some receipts. Basically, show us evidence. And we're seeing more and more that people rely on a common law trademark, which is okay, but you have to prove it. So I don't expect that you saw anything about Capital Bay Funding, did you, Dave?
No, but I did a quick SpyFu search on search which websites turn up for Capital Bay around the United States. And there's capbaypartners.com. There's a real estate firm. There's an underwriting insurance firm. There's a place in Luxembourg. On a Google search, it shows up as Capital Bay Funding in Luxembourg. So I think the name is used in many parts of the world by many different people. If I were to go to open corporates, what would that show? Capital Bay. Not really distinct, like distinctive. It's
Yeah, Capital Bay sounds.
like it's a common term. So open corporate shows 2,100 businesses. Let's see, exclude inactive. There is at least 1,200, but there's no guarantee that's the right order. Like a lot of them are Bay Capital. So let's see.
Yeah, Capital Bay sounds not generic, because it's certainly not generic, but Capital Bay Funding sounds like there'd be several companies with it. I mean, as I said, namers, us domain investors.
Yeah, absolutely. There's a lot.
Okay,
So
go ahead.
hundreds.
Yeah, that's anyway, there was some sales I wanted to mention. There's a GoDaddy auction going on right now. I'm not going to promote it because I don't have a link to it where I can make some money off of it, but they got a lot of names that, some pretty interesting stuff. I saw it on domaining.com. And I'm still not clear on domaining.com. I think it's Francois who runs the site. I reach out and say, hey, I want to promote domain name law, and it's, I don't know, a couple grand a week or something. When I know all these other people on that feed aren't paying this kind of money, maybe they grandfathered in or he's friends with them. I've been friends with people before in the past, and yeah, I'll do things for my friends. But the point is, so I go to domaining.com all the time. I still don't know how that works. I'm not going to be paying. Okay. I was, enough to do this show every week. We're on show 233. We've done it 4.5 years. Very few people care. We do it because, we like domain name law that much. But so I was on domaining.com, and I see there's the link for the GoDaddy auction. And I don't know, does every one of those links pay? I just don't know the story, but they tried to, I got charged. I was going to be charged a lot. Okay, so they're pretty good names there, but I wanted to say playid.com sold on Cito this past week for 60K. Interesting, but was more interesting to me is 3character.coms are, I sold one a couple weeks back. I see that they're really, I sold several, some privately. I sold RR9 and VV7. I see X77.com sold yesterday on GoDaddy, 50 grand. So we're seeing a lot of, and then I see in that GoDaddy auction I just mentioned, I see like D60, which there's a big difference when you have a letter, number, letter, number, or letter, number, letter. Those are the least attractive. I tell you, because I know the market, especially over in Asia, they are always requesting from me, do you have any NNLs or LLNs? Right? So we want, this is for the 3 character. But anyway, I did see D60 already got a $500 bid, and that's really unusual. End users will pay for a 3 character if there's an end user for your goofy 3 character, especially if it's like L5D, which looks like LSD, which I own. But they're I have a lot of them, 50. Only the ones I've sold are the unique patterns, like I said, LLN or NNL. And those, I even reached out to buyers, even though I do have, anyway, I had Asian brokers always asking me about them. So finally, when I wanted to get some money, I contacted them and said, hey, you guys still interested in these? And of course they are. So I'm just seeing more and more these things are selling CCCs, 3 character. So if you can find some, and you can, less than 1,000, less than 500, a lot, maybe pick one up. The short keystrokes are the future. Okay, people love that stuff, and especially maybe you don't, and maybe all the people in Europe don't, but in Eastern Europe, they're starting to come around. I'm just kidding, but mostly in Asia.
Well, there's a software called V0 for 5 coding, and there's O3, the model that OpenAI has. So I think that there's going to be a market for these 2-letter combinations, so a number letter or letter number.
Yeah, there are hard sells. I saw Arif with his thumb down, and I mean, I can play both sides. I can agree with him that it's like you hold these things. If I was Arif, I'd say, Todd, you bought them, you hold forever, 20 years. You hardly get any interest for them. They're just so random, and it's true. That's true. So that's just a fact. Short keystrokes never change, though. Short. So you're really playing the curve, and that's like we all do with domain investing. What may be something in the future? So it's just the same to me as on a keyword. You're really banking on, and you're banking on that short keystroke, short numbers. By the way, I did have a sale that can't see if they've paid yet. It was on Atom, a 4-letter, and I got an email earlier, and it says congratulations. It sold. I don't have any premium. I have it in my own little marketplace, 7.5%. If it said they're waiting to check on the payment, I guess, but it's totally random. It was one of the ones that I kept that wasn't one of my quad premiums. But the point is, we'll see if they pay, and maybe I'll report anyway. I know Adam does anyway, but I don't know. I'm just over. It's like not. I don't know, sharing these things publicly. It's never benefited me, but yeah. So but random, short. I just, it's, I don't know. Definitely not better than brandables. When I think of what Sten would tell us, if you have really some gift in naming, and you do find, words that combine 2 words that mean something and they happen to go together, or just a flat out 2-word, usually .com, but I guess now you can even, .ai, .org, some 2 words that are really attractive. There's, definitely, I think more meaning behind it, and then there's more people looking for those, because it certainly is random when you have a random 4-letter, random 3-character. But I just, default to, you are always going to have the shortness, and companies, like I said, with a 4-letter, sometimes they'll think, we can't get our 3-letter, let's get a 4-letter with our first 3 letters in it, and then we'll, play a wild card with the last letter or something like that. It certainly happens. All right, so enough with the horse hockey. We'll have Jeff back next week, giving us an ICANN 83 recap. It's in Prague, and like he said, he told me he's having some conversations with some folks about some things we're doing. TLDstrategies.com. If you are applying for a new GTLD and ICANN's next round, there's no better place to work with is TLD Strategies. That's a joint venture that Jeff and I created with our two companies, JJN Solutions and American Business Capital. And we are confident we can offer what other consultants or other providers, say in this specific space, can provide because of our backgrounds, really a lot of Jeff's connections, but legal and financial ability to give legal advice and financial advice, and then help you all the way through from start to finish. So if you know anybody or yourself, and it can't be individuals as we talked about last week or sole proprietorships, but we can certainly tell you or help you with formation as well if you have any intention or you know somebody who has intention to apply for the GTLD and ICANN's next round. Go to tldstrategies.com and book a meeting. We'll take it from there. Okay, our first case today, David, this one I know got your goat a little bit. I knew how to put these in here. These are a lot of, I don't know, well, I'm not going to ruin it for them yet, but a lot of things that are going to make people mad. I won't give away all this first case, and I'll throw it to you, David, and you can give some facts about it too. But first I'll say the domain is tempil.com, tempil.com. The complainant in this case, LACO Industries, maybe it's LACO Industries, been around since 1941 in Illinois. They're going after, it says Pointer Angelina from Denmark. I don't know, they have their names backwards there, but so let's just call her Angelina from Denmark. The complainant has a USPTO registration since 2004. Like I just mentioned, they say they've been around since 1941, but so at least for 20 years they've had their USPTO registration. They design and manufacture these temperature indicators for technology. I don't know. It sounds, Tempil. Okay, so cute little name for their temperature indicators. I don't know. Is it like for a computer to see if it's heating up? I don't know. Sounds like it. The complainant says the respondent does not have legitimate interest in the domain name. Well, just to go through the the complainant, goes through the standard bullshit, and that is, in this case, the respondent didn't reply, but they go through the standard bullshit of, they have to say it because you build this case, and then the panelist says the only thing we can do is take your word for it if the respondent doesn't rebut it. So the complainant says they don't have legitimate interest in this domain name. We didn't license them or authorize them to use this domain name. They don't use it in a bona fide way, because they're in this case they weren't offering goods or services or a legitimate non-commercial use of it or even fair use, nominative fair use of it. So the complainant goes through and just says all this stuff like they do in all cases, says, and then adds that, they're displaying gambling ads or links to third parties and so on, and just feels like this is not legitimate. I say the respondent didn't answer back, and there's several more facts to this case. David, jump in and tell us a few more facts and then go to the decision.
Okay, so the name was registered recently. I think it was last year. And yeah, the person who owns it is Danish. And Danish, the way you spell temple in Danish is Tempel, but Temil could be like a typo version of that. This person had monetized it through an Asian registrar. I think the registrar's G name, and they picked it up on the drop. And so anyway, she's running ads there that are zero clicks. So I guess, if they test your browser, I didn't see any ads because I use a private browser, so it didn't feed me any ads. It just gave me somebody's ID page with horned animal or something. But there's 6 active businesses in the United States with the word temple in it. and none of those own the trademark or relate to the complainant. This complainant's product is a temperature stick, and there's something called Temple Ink, and what they do is they chalk mark, say, a boiler, and when it turns a certain color, it tells you, oh, reach a certain temperature. So it's a temperature indicator just by, with a chalk pen. The person who has temp stick gets a lot more traffic and spends a lot more money for PPC ads, but they didn't target this particular domain name, and this domain name did not have any confusingly similar ads. They were unrelated. And the part that I didn't like about this decision, like it was totally defendable by this person, but this panelist goes ahead and cites this old Fox case, Fox News Network versus Reed, saying that the respondents used the disputed name to generate revenue via advertisement and affiliate fees is not a bona fide offering of goods or services. Well, ICANN did a study in 2021 and found that 61% of all domain names registered are actually monetized with PPC ads. Just one moment.
Okay. Good.
And, I remember the case we talked about a couple of years ago with the Royal Caribbean complaint against this person who had anonymized ads there, but they were showing the Star of the Sea school or church in San Pedro for the advertisement. And so that was found to be like, oh, that's common meaning of Star of the Sea and not confusingly similar to Royal Caribbean. And the use of PPC ads that were unrelated to anything that the complainant is was deemed to be legitimate. So why are panelists still citing these old cases? Is it because they're biased? Is this like a repertoire that complainants stick in, and unless the respondent sticks in their own other precedents that contradict those propositions, like do you lose automatically? Yeah, I think that's the case. You really need to know your cases that support your PPC ads if you're doing that.
David, there's some facts in this case that really, well, I think people would like to know. The domain, once again, is tempil.com. This domain was registered by the complainant who inadvertently dropped it. Okay, so you made a mistake and you let it drop. It was registered 2/27/25, so just earlier this year. But what was interesting, I did see it on NameBio that it sold for $226 just back in January of 23 for 200, yeah, like I said, for $226. So I think that this person may have picked it up from the person who bought it at NameJet. Somebody got it on NameJet, and they may have, maybe they were the one that picked it up, but I don't know why we have the registration date 2/27/25. Interesting because this company did drop it, and I didn't, we only see so much in the summary of the case. So how the name bio fact that I just mentioned that shows it sold on NameJet for $226 in January 23. I don't know where that fits in here because without that, I would have just thought, okay, so they forgot to renew it. This person catches it on the drop, and that's how they got it. So I don't know where that sale comes in. But the panelist here, so the panelist steps in and says, okay, the respondent didn't reply. The complainant makes all these claims, that, hey, now it's going to gambling ads. And then it says, complainant says that the respondent registered the domain to divert traffic to display porn. What are the, so basically it was all these different ads, and maybe there were some adult ads, I don't know. But there were certainly some gambling ads, and there were some other links to other third-party sites with no connection to the domain, meaning, okay, so they think, the complainant thinks TEMPIL means something, and, like its product, and any link that isn't related to these temperature indicators means that it's, has links that are unrelated to the domain name. The panelist said, in a nutshell, the complainant successfully made their case. Okay, and I say it all the time, that prima facie case. That means they say all this stuff. Usually, if there's evidence to it, that really then I can understand the panelists saying they've successfully made their case. But we're going to see throughout some of the cases today, but you hear us talk about it each week, the complainants say the same thing. And if you're a complainant in a case and you spend the $1,500, well, you don't know if they're going to answer it or not at the beginning. But what I would recommend is, yeah, always do that. They're not known by the name. That person and their, and then they don't even have a complete address in their, they just throw all the shit at the wall. They don't have a complete address that they register the name with. They are hiding behind privacy, but we didn't license them or authorize them, and they're not using it in a legitimate way. By offering a really, goods or services. So we see some panelists say, hey, it's okay to have a PPC page. Like David said, millions of domains are on PPC landers. That's why it was created. These landers were created. It's legal to have your domain going to a lander. Of course, it's legal, and it should be okay in a UDRP. As long as there's not other circumstances or other facts that lead the panelists really to see that you are targeting that complainant. But okay, so the panelists said, with no explanation why the domain is showing gambling ads and other unrelated content, that's not a bona fide use until we understand why this person believes gambling ads at 10pill.com make sense. We're not gonna side with him. And the panelists also said, the complainant owned this name before it was hijacked from them. Hijacked. That the panelists used that word.
It wasn't hijacked.
Yeah.
They dropped it in 2018. And in 2023, it had a WordPress site on there. Blow your mind. It's just a standard lander. They installed WordPress and they never did anything with it, and then they dropped the domain. So yeah, they hadn't had it since 2018. So they lied. Nobody hijacked.
Yeah, so that makes sense then why somebody picked it up on Namejet, and then they may have dropped it. But anyway, tempil.com is the domain name. Of course, the company with the trademark for this product, tempil, is like, damn, we finally realized, I don't know, late, we don't have it. We want the .com. Of course they want the .com, so they go after it. In this case, Nick Smith is the panelist, and he said, tempil, that's a coined mark, meaning that doesn't mean anything. Somebody created that. So he ruled 1, 2, 3 against the respondent for the complainant. He transferred the domain name. What David and I feel is, first of all, tempil, that's a misspelling of temple, okay? Of no matter how you spell temple, like a, steeple, temple, church. Anyway, so flat out as a naming person, you can understand why there's several reasons, including that temperature connection, tempil, but also the connection to, like I said, a temple. So without a response, these panelists will just take the word of the complainant and likely rule against you. So, I don't know, we say this every week. Yeah, you need to respond, even if it's some simple response. But one thing to always include in your response, is under penalty of perjury, I am not targeting when I purchased this, I didn't target them. If you didn't know about them, then say under penalty of perjury, was not aware of this complainant and their trademark. So I'm not telling you to lie. Only do that if you really weren't aware of them, but you can certainly say that you weren't targeting them. But the point is, you need to answer. So yeah, Nick Smith is going to have to answer to us when we get a hold of him. He transferred this domain name. Basically just, like I said, panelists feel like they have the right when the complainant makes a lot of accusations. They're supposed to have a lot of evidence, but we don't get to see it with the summary. But really, they usually just make those same claims over and over. Hey, you're not known by that name. How about Arif? You're listening. How about if I go through all your names? You're not known by that name. Of course, you're not known by any name. I'm known by a couple of mine, ABC Productions and Todd Ryan. But usually you're not known by. Okay, so that was a transfer. So that's just to get you warmed up that, people will take your stuff right from you. This next one, bpce.xyz. So it's a 4-letter, bpce.xyz. For those listening, that's what we call a quad premium Of course, it's a .xyz, so it makes it nearly worthless. But anyway, so it's a quad premium, meaning all those letters in America, and we call that a quad premium in America, are used quite a bit, are considered sort of like primary letters that are used more frequently than J, K, Q, Z, W, and so on. So it's a quad premium bpce.xyz, just registered in February of 2025. The complainant in this case is BPCE out of France. Of course, you all know them. Don't act like you don't. It's like Coca-Cola, isn't it? Okay, so that's versus U King. It's Qing. U King out of China. So this company BPCE, of course, I just learned about them after this, looking at this case. I didn't know them. They're headquartered in Paris, second largest banking group in France. And we act like we're supposed to know this. Anyway, so I didn't know this, and I'm in banking, meaning I go to the ready teller still. Security Pacific, 1985. Complainant has 105,000 employees, 36 million customers, 40 countries. So my point is, it is a big company, international company. I've never heard of them still, but they've had a French trademark since 2009, EU 2010, a US trademark since 2019. Okay, the domain in question here, once again, bpce.xyz. So this company, BPCE, I think it's important to know that they're on they're on bpce.fr, because I know they're not on bpce.com. They don't own that. That's owned by a company called Bridgers and Paxton. So, of course, I'm sure they'd love the bpce.com. They know they don't have the rights to that. They know there's another company that uses that as their, it's their initials, it's their acronym. So uses that. Of course, they don't go after BPCE. They go after this .xyz for what reason? I don't know. Okay, so the respondent, again, did not reply. So the complainant makes their standard bullshit case again. David, do you have some facts? I got more facts to share before I get to the decision, but what do you see in this case? What can you share?
So it's listed for sale on GoDaddy. Has a GoDaddy lander with a buy it now price of $14.50. So there's this domain name is registered in 37 TLDs. There's 342 domains that start with the term BPCE. There are 120 businesses registered with the term BPCE, and 66 of them are in France. Yeah, this complaint is a bank, and there's some leasing companies in there. So there, some of them, or most of them, are probably related to the French company. But I think that this is like a fair game name because there are 120 businesses, and how is anybody in China supposed to know about this bank in France? I didn't know about it. Did you know about it? No, you said you didn't.
Well, David, yeah, why doesn't the company that owns bpce.com have rights to this name? No one has rights to
Yeah.
this name if they're not being targeted. It's it's first come, first serve. Okay, that's how it should be. And only if this registrant was targeting someone, and like you said, they had a lander, $1,450. I hope they did that. I'm assuming maybe they did that because they know UDRP costs $1,500 to file. It might be a little cheaper in Czech Republic. That's where Prague is. Okay, so I think it's a little cheaper maybe in Canada, $1,200. The point is, this person priced it at a price that you would think the company would buy it as opposed to filing a UDRP, because it's going to cost more. The filing fee is usually $1,500 for a WIPO, and maybe I think this was a WIPO case. I can see real fast. If anybody want to follow along with the links, go to dnlshow.com. Yeah, this is a WIPO case /outline, and you can see the outline, or just go to dnlshow.com and you'll see the outline link at the top. But so this is a WIPO case, $1,500 cost you to file, and yeah, let's see here. And if you want to, this is a single member panel. This one was Yi Jun Tian was the panelist. But okay, so this person lists it for $14.50, but yet this fucking complainant doesn't want to buy it, and that's how people are. They're so they and not and I'm that way too. Somebody buys something, even outbid you anyway, gets right in front of you, and then they come want to sell it to you. You just got a bad taste in your mouth, so you don't want to do it. So this company, I'm not saying they did feel like they were being targeted, I guess, but there was no evidence that this respondent targeted them. The respondent didn't respond. The complainant made their standard case of, we didn't license this, we didn't do this. But the panelists said there's sided with the complainant. The panelists said there's no evidence the disputed domain was used in a bona fide way. So they look at the person has this name, they have a lander, 1,450. So that's not a bona fide use. You sell domain names. Some panelists know if there's not any bad, clear targeting, and there's no, really some fraudulent actions, it's first come, first serve. This person has a right to register the name, has a right to offer it for sale. This panelist says no. There's no evidence that the complainant licensed or permitted the respondent to use it. The respondent basically needed to, and finally, that there was no evidence that the respondent is commonly known by bpce.xyz. Of course they're not. So this panelist just really said there's no conceivable way that the respondent was unaware of the complainant's trademark at the time of registration. So this was a Chinese domain registrant. I'm in the U.S. I've never heard of this French bank, banking group. So the panelist said this just doesn't make sense with all their employees and all this stuff, how this Chinese domain registrant, doesn't know about them. It's inconceivable. So we're going to rule bad faith. So that's what it was. 1, 2, 3. And when I say 1, 2, 3, 1, the complainant showed they have a trademark, which is understood. So they have a trademark for BPCE. Number 2, the panelist agreed with complainant. They don't have a legitimate interest or, in this name, and they haven't shown that they have. They need to answer. And number 3, about the bad faith, that was registered and used in bad faith. So they're saying it was registered in bad faith because it was registered in February of 2025, but the it's an and used in bad faith because there was a lander with a price of 1,450. We've seen it where the price is super high, like in the Converse.co case is one of them I remember. You're targeting Converse if you got a price of 200,000 or whatever it was. But in this case, they felt just selling the name was used in bad faith. So are we allowed to do this, David? Can we have a lander with a price on it or what?
Yeah, there's a whole lot of decisions justifying selling domain names. So, and again, if you respond properly with the right decisions, right precedents, you're going to win. But if you don't respond, you lose. And these guys are like steamrolling. This is trademark bullying because this was a loser case, but they lucked out with the hanging UDRP panelist. It's like the hanging judge in the Old West.
Yeah. Oh, that was deadly. Okay, well, this next case is, I call it 2A. Okay, so that was a transfer. They transferred bpce.xyz. Who wants the .xyz? It's just ridiculous. This company, there was no evidence of targeting. I don't know if they were targeting it, but no evidence that we see. And this company, of course, doesn't doesn't go after BPCE because, of course, there's, that company has legitimate use and put it to use. But you either need to respond to these complaints, but what better than that, I guess, is, well, you need to do 2 things: respond and put it to use. You got to have it. But domain investors, we don't put it to use. Anyway, that's why we're here at Domain Name Law every Tuesday, noon Pacific, 3 p.m. Eastern, to really speak to domain investors about here's different ways your names get taken from you. And believe it or not, this person here had bpce.xyz listed at $14.50. That'd be the least thing I'd be worried about, is getting a UDRP on that. And that person did. This case that's also related, bpceinvestment.com. But investment is spelled investmnt.com. So keep this in mind. It's investment spelled wrong without the second E. bpceinvestment.com, misspelled. Same complainant in the case, BPCE, French bank, you guys have heard of them, against Plysium. I don't know who that is, Plysium. It's a company out of Benin, anyway, West Africa. The complainant, I don't need to tell you, they don't own BPCE. I think I already mentioned that. They're on the .fr. They also have bpce.com. So those are the two names that they use. One is for their institutional services, I guess. But in this case, the disputed domain name redirects to, well, first redirected to like one of those index sites where you go and it says index and it looks like you're looking at the files for the website. That's what it was initially at when the complaint was filed, I believe. When the decision came down, it had been redirected to an Italian, I think it's still up there because I went to it, Italian site proposing financial services. So, of course,
It's not redirected, but actually
yeah,
hosted there. It's like an Italian Financia Plus is hosted on this particular domain name.
yeah, looked like a
So
legitimate
the name
business
doesn't
that does
match.
investments. And anyway, so this company, BPCE out of France, goes after now this name. And these were both recent cases. One was this past week, one was like 2 weeks ago. But so we see BPCE, the French company, is out there, trying to handle business. But they're not going to let anybody, I guess, infringe. If it was an infringement case, it should be going to court. But they're not letting anybody cyber squat on anything related to their mark. But once again, in this case, the the respondent didn't reply, and the panelist said this domain name is perfect, is well suited to confuse internet users. So they thought, you know what, BPCE investment without the E, something's fishy there. It is confusing. Didn't even really, I shouldn't say, I mean, I think I read the case pretty good. Talk about possible legitimate use, because it looks like there is legitimate use with what the respondent is doing with the name, but still, Muriel Boydens, who was the panelist in this case, ruled 1-2-3 against the respondent again. So BPCE also won this domain name. So now they're walking around. They got the .xyz with the 4-letter. They got BPCE investment, messed up spelling. I don't even know why they would want this name, but check your portfolios. If you have a BPCE anything, it'd probably come after you. But another transfer. So we got 3 transfers so far. Any comments about this BPC investment, David? Any more?
Yeah, it's interesting. It doesn't get any traffic. It's a typo of BPCE investment. And the panelist, she's based in Belgium and she does things in French, but the decision is in English. And the respondent is somebody who's in the country that's between Togo and Nigeria, little country. So did he intend to do something else? And somebody, you said it had an index page, and now I see the Italian site. That could have been, I've got some domain names that I pointed to at a hosting company that I never set up my own website at, and all of a sudden somebody else's website's there. And I'm like, oh, I have to now change my DNS so I can not have that site resolve and rebuild it someplace else. That's a problem. So that could have happened here. This bank does not have a trademark in the EU. They only have a French trademark and trademarks in Canada, the US, Australia, but they skipped the EU. They don't have any trademarks in Italy or the EU. So it's an interesting situation, or Africa. I guess it could have been defended, but
yeah, I mean, well, they all have a defense because this one is more difficult, I think, than the bpce.xyz, because that's just an acronym, some letters. But with the investment, it shows that you are claiming to be in that space, I guess. And then they have that website. So I think they have a great defense of legitimate use, and they're in a different, I don't know, of course, the registrant's in a different country, but one, I think there definitely is a defense there, um, but they'd have to, what was the targeting? Like in any of these cases, the domain registrant supposedly registered the name because they were aware of the trademark owner, and they were not just aware of them, but were targeting them, trying to disrupt their business or sell them the name or something. Because you can know someone has a trademark. There's, like I said, Purple. There's a bedding company or some mattress company that you could know that somebody has a trademark. Delta, 10, 20, 100 companies have Delta in their trademark, but that doesn't mean you can't own a name with Delta in it. So, one, you have to be aware of the mark, but you really have to be targeting the mark in a sense where you're trying to mess with a specific trademark owner. So I just don't see it in this case. But the panelist, when you don't answer, the panelist just does okay, we believe everything they say. We have some questions for you, respondent. You don't answer, we're holding it against you. Okay, this next case, fearofqod.com. So there's a company, fearofgod.com. They're out of LA, and they sell luxury streetwear. I mean, I've heard of them, but to me, it's really such a generic phrase, fear of God. Doesn't everyone, you hear that all the time. He's got the fear of God in him. He's a Lord fearing man. I mean, I can't remember the different phrases, but definitely fear of God. People will say, yeah, I have the fear of God in me. But anyway, the domain name is fear of QOD, fear of cod, which is, a lot of people are afraid of fish, and that's not how you spell it. So anyway, this complainant is an LA company, 2011. I told you sells luxury stuff. They're, in Nordstrom. They're in Saks Fifth Avenue. They've had partnerships, apparently, according to the complaint, with Nike, with major companies. So it's some kind of luxury brand that's, like I said, streetwear. So fear of God, they have been around. I'm sure some of you have heard of them, especially those folks in LA. So the complainant is on the fearofgod.com, pretty good domain name, Fear of God. It's your brand. It's a phrase. The complainant has had trademarks in the EU since 2018 and the US since 2019. So I don't know if they were doing business over there first. It says LA company, but the disputed domain resolves to, and I went there it says to a name silo PPC page. Now let me go back there again. I don't know. Did you see that? Fear of QOD. In this case, yeah, I remember this page. It's a Cloudflare hosting now. And oh yeah, now it says missing something important. So they've changed the hosting from it was the name silo parked page to now it's on Cloudflare, and it's just not resolving. Something's missing here. So the name hasn't been transferred yet. But the panelist in this case, Scott Blackmer, said the complainant has established its prima facie case. The respondent has not replied. So the respondent has offered no explanation why he registered this domain name, fearofqod.com. I mean, if I'm just sitting there, I'm a panelist, and the guy didn't reply, I could imagine he probably wanted it because it's similar to the phrase fear of God. Now, I would take a look at all the evidence the complainant provided and said, how is he targeting you? What are they doing specifically to target you? And in this case, it was simply a name silo PPC page. I'm sure if Jeff was here, he'd have some reason, why it's ridiculous that we're, being penalized for our registrar's PPC pages. But what do you feel about this decision? This was another transfer, David.
I think it's a stupid decision. I dare them to go after Adidas for trademark infringement on Fear of God Athletics basketball shoes, unless they're doing a partnership there. But that could be. They might be doing a partnership where Adidas does sell shoes for them, but they don't sell those same shoes on their own website. So can't really say. Yeah, I think it's a generic term, and it should never have been transferred, even though it is a typo of Fear of God.
All right, yeah, that was a transfer. We got Domain X Hunt on stage. If you have a question that's related to this or a comment, let us know now. And if not, we'll take your question after we do our next case. But what's up? Do you have a comment related to this case or something we talked about already?
Yeah, Todd. Like it's great to be here. Like, thanks for hosting this space. So yeah, basically not for this case, but it was a different case which I wanted to talk. Is it good time to talk, or after completion of this discussion would be good to ask?
Well, thanks for asking. Yeah, well, let us do the final case, and then I was going to mention. I'm glad you joined us on stage. I was going to mention that yeah, we got a little extra time today because we were blowing through our cases. That if anybody has a legal question, a domain name law question, anything related to legalities of owning a domain name or anything even closely related, come on, let's talk about it. So yes, we'll finish our last case, and then I'll throw it to you, and you can let us know what you want to talk about. So our final case today is farewell.com. FAIRWELL.com. Okay, pretty cool name, right? Farewell. I mean, we know there's a word FAREWELL, right? Goodbye, farewell. So it is certainly a play on that name. And the complainant in this case, Capstan LLC, I don't know. They're a dispute resolution service. I don't know if there's lawyers over there or not. Probably a lawyer or two that's involved. Versus Vicky Townsend. They're both in U.S. This Vicky Townsend, a unique case because the panelist even said, and the panelist Robert Badgley said, both the complainant and the respondent added so much horseshit in the complaint, meaning they added so many details and facts that weren't important, but they were going back and forth um, because the complainant provides alternative dispute resolution services, I mentioned. They focus on areas of divorce and family law disputes, and they also offer some software related to that. The complainants had a USPTO trademark registration since 2018. That was late in 2018, but they first started using it in February of 2018, and they're on the domain farewell, FAIRWELL, mediation.com. So they're on farewell mediation, just a longer version of the disputed domain farewell.com. The this is the mark. The disputed domain name resolves to the respondent's page offering divorce mediation, life coaching, etc. So the respondent in this case, similar business, and the panelist notes that and says, of course, the name FAIRWELL is a play on farewell, goodbye. If you're doing dispute mediation services, especially for something like a divorce, it is a neat little play, meaning farewell. You're saying goodbye, but you want to do it in a fair way, or not you want to, but it's by using their service, I guess they're saying that we'll make sure you get a fair result out of this thing. But anyway, so both the complainant and the respondent were offering the same service. Like I said, a lot of details. I'll just give you a couple, then I'll throw it to David and we'll wrap this case up. But the respondent cites, let's see here. The respondent has a different little version of the mark on its website. So the panelists did note that it wasn't the same. And the respondent sent in with their response a GoDaddy receipt showing that the domain was sold for $5,199 on in April 2017. Interesting thing, they weren't the ones that bought it. They throw in this receipt to show, hey, look, this name was purchased in 2017. I guess they wanted to show that it was before the trademark was registered by the complainant. And they say this, the respondent further in a later email to the panelist, a later submission says, this third party bought the domain name in 2017 and has allowed them, the respondent, to use it along with the associated trademark. So the respondent's saying, hey, this name was bought by somebody else who started doing business on it, has a trademark on it. I'm acquiring it from this domain owner who's also the trademark owner, and we're just finalizing a deal now here in June 2025. So the respondent, says we're preparing to use it, supplied, documents from the third party, that the third party's showing we do have rights to this domain name and we do have this USPTO trademark, and here's our permission for the respondent to use it. So the panelist is getting all this information, like, what's going on here. But the well, I guess I can say more. David, did you want to talk about the complainant was aware of these third party trademark and filed an opposition? If you can, take it from there and see what you can add.
Well, both parties have a registered trademark, and that's a big deal. So Capstan got their trademark. They applied in 2016 and notice allowance 2017, but they're on capstan.com. And the domain owner, I guess bought the domain name from Melissa McKeaton from Montana. And the thing is, these two companies or law companies are in different geographic areas. So the Minnesota-based complainant is far away from the Florida-based respondent. It's interesting that the domain name was previously owned by somebody in Montana doing something very similar. Montana and Minnesota are not that far apart in comparison. But yeah, I would say that this is not something that should be in the UDRP. This complex infringement analysis, and since they both have a trademark registration, she has a contract from the prior owner. She enjoys those rights. So there are other companies with the trademark Farewell, like a cup company. Live Nation has a trademark for Farewell. So it's not a unique term. And you know what? Capstan has software as a service. And meanwhile, Melissa Kay has a life coaching service in the field of divorce and life coaching. So that is a totally different thing.
Yeah, in this case with the complainant, as I mentioned, said, we know they got a trademark and we filed an opposition to it. All right, well, the panelist said, thank you for all that information. As he mentioned, it is a play on words, so it's easy to understand that multiple parties would think of it. And he did bring up what David mentioned. You're in Minnesota, they're in Florida. In a real trademark dispute, if it is a Lanham Act violation, then and you have a registered trademark with the USPTO, then you can say you want to enforce it nationwide. Here in this particular forum, a UDRP, the panelists had some questions on how well your mark was known down there in Florida, because we're trying to figure out, was this person targeting you, trying to disrupt your business or really make money off of your mark? There's no indications of that at all. It's like a separate business. But anyway, the panelists agreed with you, David, saying this is potentially a trademark infringement case. Like I said, a Lanham Act violation, which means if you want to take them to court, maybe, I don't even know. But Robert Badgley, who was the panelist, said, you have a trademark. We went ahead and let you go forward with the case, but we're not even going to rule on whether or not they have legitimate interest. Although the panelist looked as though he felt that they did have a legitimate interest. He just ruled on whether there was a bad faith registration and they targeted. And since the name was owned by someone who had a trademark prior, that there was no bad faith registration. So anyway, this was a complaint denied. We'll leave everything on a good note. So this person got to keep their name, pretty cool name, Fairwell. And that's it. Everybody can go to bed. No, we have
I
a
have
question.
another comment about this.
Yeah, go ahead.
So yeah, there was actually an opposition, but they agreed to change the terms of the registration, so it did not include a software as a service component to it. And so that's estoppel. This opposition was terminated based upon this agreement and the alternative description of the goods and services. So therefore, they cannot file this. They are stopped. They cannot file a court complaint. They are dead in the water.
So they left that out, huh?
Oh yeah, that's a big deal.
Complainant left that out, yeah. No, thanks, David. So anyway, the decision was correct here. I mean, basically, we think it's always correct. Usually, the domain owner gets to keep his name. All right. Well, it's the top of the hour, but we have a special guest. I mean, okay, so he's here. Domain Hunt. What was your question? Did you have? Thing.
I had registered two extensions, freestylechess.co and freestylechess.ae. But later, when I checked, the domain was a registered trademark, and it's not registered in US. US registration is not found when I check the trademark registration, but it is registered somewhere in Hamburg. Um, my question was will there be a issue? Because I don't have any intention of doing any trademark infringement or something negative intention, but I'm trying to reach out to the party and trying to negotiate and provide them the extensions. So, will there be any issues in this case? Any suggestion from community?
So are you saying you're trying to target the trademark owner with your domain names and try to sell it to them?
That's correct. But when I registered it, I had not checked about the trademark. But when after the registration, slowly I came to know that it's a trademark. So that is why I wanted some understanding about it.
Are they on the owners that you're looking to? Are they on freestyle-chess.com? Do you know what?
Yeah, that's correct. That's correct.
Okay. So I'm wondering who has freestyle chess. But okay, so I would say, David hit on it. So are you targeting them? Well, like you said, listen, I didn't even know about them at the time I registered. I didn't know there were any trademarks. Freestyle chess to me sounds like a generic name. Sounds like a style of chess. And as I look online, I see it is a style of chess. And what I would suggest if you're reaching out to the freestyle-chess.com, you would want to make clear that one, since you didn't know about them when you acquired the name, of course you could put that in there, but I would put what the reason why you acquired the name is because it's generic, and I would reach out to several people, even if they don't use freestyle chess in their domain name, if they offer chess, online chess, if they are any chess organization that um, that plays freestyle chess, I would say before you reach out to just one company, especially freestyle-chess, I would have an email that says I'm reaching out to several different organizations, entities that I think would benefit from this domain name, who have a relation to playing freestyle chess, the generic version. Basically, you don't, even if you didn't registered in bad faith, you didn't know about them, so how could you? Well, you still don't want to get yourself caught up in targeting, because they can still hold it against you and
Yeah,
think, okay, you didn't know about them
that's correct.
apparently. But so anyway, I know John Berryhill would say, if you're going to reach out to numerous folks about the name, even if one or two seem more likely, the more likely candidate, and then make sure in that email that they're aware that you're reaching out to several people. And like I said, you can also add in, the definition of it, really, that it is a generic, in a generic sense. But what was the second one? Freestylechess.co, and what was the second extension?
Yeah, dot AE. Dot AE. It's basically UAE.
Oh, AE.
UAE
Okay, yeah,
extension.
AE. Okay. Well, David, any
Yeah,
other?
so you have to check the trademarks, go to the White Pro Brand Index and check to see, because there is a registered trademark for freestyle chess in Germany and in some other countries, not in the United States. So
Yeah,
you really
not
need to
in
do your
the United
homework
States.
first, and then see who registered the domain name first. Did you register the domain name before they got their trademark or after? And that's the
No,
key
no,
thing.
no. Is the owner freestylechess.com and freestyle-chess.com. They registered it first.
Yeah, but are they a trademark holder? Because some of them, they might have that and they might be the most successful, but they're not the trademark owner. So that's what I'm saying. You have to go to the brand index on the WIPO website and see who are the brand owners, so you can avoid targeting those people, especially if they register their trademarks before you got your domain names.
Okay.
You sound like he didn't. Yeah, that's right. I'm like you. Yeah, okay, David. No, but what David's saying is, check out the USPTO, but check out. Well, I guess say it again, David. What should he check out before he
It's
contacts anybody?
it's the brand database at wipo.int. So branddb.wipo.int. And the German trademark was registered in November 2024. So it's a recent registration. But there was also a registration in Qatar in 2024. Um, you have to do a full search here. There's like a whole bunch of them. This is like a long.
Okay.
Egypt.
Yeah, I
Yeah.
got that site, branddb, vipu.int.
Yeah, I mean,
Yeah.
if you search brand
branddb.wipo.
database WIPO, you're going to find it.
Yeah.
Yeah.
branddp.wipo.int. Yeah. I like that .int. I wonder if there's going to be an INTL like international this next round. But I like .int. David, what's the restrictions on buying a .int?
So you can't. It's only WIPO related activities, and probably not even UN. I don't know.
No one can. I gotta. All right, I'm going to take your word for that. Uh, yeah, and I wanted to say too, David. And sometimes I give you a hard time, but you're the you're. I appreciate you so much for being here. I'm not going to say too many nice things today, but you're always, here from the start. And if you ever, showed up at the Names Con or any of these other events I see, anything I'm doing, you sit at the head of the table, meaning you're definitely part of any panels that I'm running. But I know you don't go there, but I just want you to know that. And also, I need to talk to you in private about some other bullshit. Anyway, that we'll start working together on some things. But okay, so Bradley's here. Brad, I was gonna have you speak, but you fucking just wanted to get. Brad snuck up here. Anybody else? Raise your hand. We're gonna be on for like another
I
5 or 10
just, yeah,
minutes.
thank
What's
you.
up, Brad?
Thank you for the show. I want to second the motion about David. He's a special man, and both of you are. I wanted to ask David about the last case and the use of the use of homonyms. How are homonyms? Because that fair and fair. How are homonyms usually handled in a trademark dispute?
Oh, there is a sound alike test. So if trademarks sound the same or look the same or have the same impression, commercial impression, then they're usually considered confusingly similar if the goods and services are in related good fields.
So it's to sound the same and look
Yes.
the same. Well, farewell and farewell sounds the same, right? So what was
Right.
the
And they have
distinguishing
to be in the same
factors there?
industry.
They were different.
If they're in different unrelated industries, so for example, spirits versus transit, transit passes, or just divorce software and transit passes. So two different things. Like you pay a fare to get on the transit, the metro in New York or whatever.
Oh, I see. Okay. And also to that other gentleman about putting chess put a definition on the website, right? Just a general definition that it's a known, experience. So it expands who can
Yeah, there's like a Wikipedia, couple Wikipedia pages for freestyle chess. I never heard of it before today, so I don't know. I don't know anything else about it. But chess.com has freestyle chess available on there, so like there's a lot of companies doing this, and depends on where you are. So just don't do it in the countries where there's a registration for it.
Got that. Got that. Thank you, David. Thank you, Ryan, and thank you, everyone. Yeah, thank you for your input. Really appreciate that.
No, thanks for joining us. And anybody else want to say anything before we should? We're going to be here for like 2 more minutes, 3 more, maybe 5 if somebody has a question. But Brad, I wanted to say a couple things. One, how many grits do you want? One, how many grits? Oh, homonyms. I can think of a sniglet for that. It's X-rated, so I won't. But anyway, I haven't heard the homonyms in a long time. But I'm glad you brought it up. And especially, I know you've held off on auto population during this interaction with me. So, okay, so Brad, how's your nephew doing with Tom Hanks's kid? Aren't they doing they're like I don't know what you call it, a band. But anyway, are you there? Can you hear me? You're not coming in. Chet Hanks is the guy's name. Yeah, we can't hear you, Brad. Right, David? Can you hear Brad?
I don't hear anybody right now other than you.
Yeah, okay, so we can't hear you, Brad, but his nephew was doing has an album. It's like Brooks and Dunn, but he's got a partnership with Tom Hanks' son, Chet Hanks, who was a rapper. Now he's singing some country songs. They had something that was just on the charts. It was an interesting and a cool video. Brad, unfortunately, we can't hear you. I see you're off mute, but can't hear a thing. All right, everybody, listen, this week on Friday rather than Thursday, Josh and I are going to do the DNX show because there's conflict of schedule on Thursday. So instead of Thursday, which is our normal time at 10 a.m. Pacific, 1 p.m. Eastern, we're going to do it Friday this week, and you can catch it on our timelines. It's Friday at 11 a.m. Pacific, 2 p.m. Eastern. So it's beautiful for you. Friday at lunchtime if you're on the West Coast, early afternoon if you're on the East Coast. So please join us. That's dnx.show is the website. I'll put together an outline here in the next day or so. I've got a lot of topics. I got a lot written down. So it's a great way to just talk solely domain investing, what's going on in the space. Nothing's off limits. I got all sorts of surprise questions I'm going to ask Josh this week too. But I sure hope you can make it. That's Friday this week, 11 a.m. Pacific, 2 p.m. Eastern. So check us out, DNX Show. That's going to do it for us today. Thanks for joining Domain Name Law. We're here every Tuesday. We'll see you next Tuesday. Have a great rest of your day.